Hi everyone, I'm David Fisher, and this is Presidential Chronicles, a series of books and videos on American history as seen through the lives of the presidents of the United States. This episode is from the life of Dwight Eisenhower, and the focus is Ike and Civil Rights. In the fall of 1957, President Dwight Eisenhower initiated one of the boldest, most impactful moves to advance the rights of civil rights in the country really ever since Reconstruction. How he got to that point is a rather cautious and even resistant journey on occasion, and that journey is what we're going to cover in this episode, going back to just before Ike became president. The 1952 Republican Convention, the state of California was going to be key in trying to put Ike over the top on the first ballot, and it wasn't his VP candidate, the senator from California, Richard Nixon, who really delivered the state. It was much more the governor, Earl Warren. And Ike got to know Warren a bit during the campaign. He was very supportive, and he basically told him, look, the first opening that occurs in the Supreme Court, if you want it, you're going to have it. Little did he know that position was actually going to be for Chief Justice, because the chief, Fred Vinson, died in September of 1953, just 9 months into Ike's term. He turned to Warren, he was nominated, and he took over. Now, there had been some civil rights cases a little bit here and there in the Vinson court, but it's really the Warren court that's going to move things forward, and they did it beginning almost right away in December of 1953. He's only been on the court for a couple of months, and they agreed to hear the case of Brown v. Board of Education of Topeka. This was a challenge to the decision that the court had made almost 60 years before in Plessy v. Ferguson that sanctioned the notion of separate but equal, basically saying segregation, public schools, that's okay. And so across the South for all these years, you would have completely white schools, completely black schools, but that notion was really starting to be challenged in a number of places based on the 14th Amendment's Equal Protection Clause. And the court had kind of been looking at this point for an opportunity to weigh in, and that's what happened when the Warren court heard the Brown case in December of 1953. Now, Dwight Eisenhower so far in civil rights had really only taken one step. It was significant. When Harry Truman, his predecessor, had issued an executive order desegregating the military, they had made some progress along those lines, but it had not been completed. And when Ike came into office, he said, first of all, we're not taking a step back. We're going to move that forward, and basically completed the full integration of the U.S. military on Ike's watch. But other than that, he was very cautious when it came to civil rights. He believed in his middle way of governance and more evolution than revolution, and was nervous about forcing change upon people too fast. He made the comment that until America had achieved reality in the concept of individual dignity and equality before the law, will not have become completely worthy of our limitless opportunities. But at the same time, he was convinced that coercive law is by itself powerless to bring about complete compliance when the great mass of public opinion is in bitter opposition. He was nervous about trying to force something that could be so impactful but also destructive to the current way of life in order to achieve that greater vision going forward. He was trying to be very cautious. And in fact, he weighed in a little bit on this when he had an opportunity to talk directly to Chief Justice Earl Warren. This was now a couple of months after they had heard the case. They hadn't decided yet. It's February of 1954, and Warren was the guest at an event at the White House. And according to Warren's memoirs, Ike pulled him aside and told him this: "These are not bad people," pointing to some Southerners. "All they're concerned about is to see that their sweet little girls are not required to sit in school alongside some big overgrown Negroes." Well, Warren was pretty upset at the comment. He didn't care for the content of Ike's statement. He also didn't like the fact that the executive seemed to be trying to get in the way of a decision that was pending before the court. But Eisenhower did approve of a friend of the court brief that actually went in the opposite direction. Attorney General Herbert Brownell was in favor of getting rid of the Plessy precedent and going forward and desegregating these schools. And he convinced Ike that it was okay for the Attorney General to send a friend of the court brief to this effect to the court, although later Ike tried to distance himself from this and basically said it was Brownell's personal opinion rather than that of the administration. So again, Ike is concerned, he's cautious when the Warren court comes together in May of 1954 to finally read their decision in Brown v. Board. Warren said, "We come then to the question presented. Does segregation of children in public schools solely on the basis of race deprive the children of the minority group of educational opportunities? We believe that it does. And not only did they believe it, they believed it unanimously. This was a big deal to Warren. He wanted a bold statement on this topic. The 14th Amendment, equal protection, we're going to get rid of segregated schools, and he got it by working with his colleagues behind the scenes to get that unanimous result. Now, neither at this point nor frankly ever did President Dwight Eisenhower ever comment on the merits of the Brown v. Board decision. But he did say this, that the Supreme Court has spoken. I am sworn to uphold the constitutional processes in this country, and I am trying. I will obey. But the question is, what was going to happen next? What did it mean to obey with implementing this decision of the court? Well, no one really knew exactly for sure, and so the court came along the next year in the Brown 2 decision and used the phrase, quote, all deliberate speed. That was their expectation in terms of desegregation of schools in the South. But even that phrase, what did that mean? As far as the South was concerned, that meant that they could kind of go as slowly as they wanted to. Well, while all of this was going on, things were certainly not static on the topic of civil rights through this Jim Crow era. Discrimination continued to occur, even atrocities continued to occur, and the Eisenhower administration was basically silent throughout all of this. In the fall of 1955, when Rosa Parks had her incident where she refused to move to the back of a bus, that launched in Montgomery, Alabama, the bus boycott, the Eisenhower administration remained basically silent, and Ike refused to meet with civil rights leader Martin Luther King to even talk about that issue. In 1956, at the Republican convention, Ike refused to allow the Republican platform to reflect any alignment with the Brown v. Board decision. And back in 1955, the Eisenhower administration was basically silent over the case of Emmett Till. Emmett Till was a 14-year-old black boy who went on vacation into Mississippi. And in Mississippi, he actually had an encounter at a store with the shopkeeper, a white woman, that she accused him of some sort of inappropriate interaction. Well, her husband and a brother-in-law, or half-brother, a couple of days later, they kidnapped Emmett Till, they tortured him, they murdered him, they lynched him, and they threw him in the river. Well, Mrs. Till, his mother, was nervous that she was going to get any justice for her son in the state of Mississippi, and so she sent a telegram to the White House basically begging the Eisenhower administration to weigh in and make sure that they would get justice for her son. She got a letter back the next day, basically said, we have no jurisdiction here. This is a local matter, it's not a federal matter, so the Eisenhower administration, frankly, there's nothing we can do. Well, not surprising, the result of the jury trial that took place, in fact, the jury came back in less than an hour. Both men were found not guilty. Later on, they admitted to the killing and the murder and the lynching of Emmett Till, but double jeopardy applied. They couldn't be retried. So that tragedy went forward, and what did the administration do? Again, almost complete silence. Really frustrating to Fred Morrow, who was actually the first black to serve on the personal staff of any president of the United States, and he wrote a memo for the record that said, my mail has been heavy and angry. Wherever I go, people have expressed disappointment that no word has come from the White House deploring this situation. There is a clamor for some kind of statement from the White House that will indicate the administration is aware of and condemns with vigor any kind of racist activity in the United States. That would not be forthcoming from this White House. The issue of federal equities and lynching wouldn't be resolved for almost 70 more years with the Emmett Till federal anti-lynching law that was passed not until 2022 when President Joe Biden signed it into law. Back to Eisenhower, the start of his second term. It's 1957, and school boards in the South, with all deliberate speed, are starting to move forward on their desegregation plans. And in Little Rock, Arkansas, the school board put out a 7-year plan to fully integrate their schools, beginning with the big public high school, Central High. The parents in this case of the existing students, of the white children, went to a federal court and sought an injunction to keep this from happening. Well, they ran into a federal judge by the name of Ronald Davies, who said, well, I have no reason to issue this injunction. We're just following the orders of the court. The school board is complying. There's nothing to stop here. Well, Orval Faubus is the governor of Arkansas, and he's getting a lot of pressure from his constituents to do something, prevent the 9 black boys and girls girls who were scheduled to start in just a couple of weeks at Central High. And so he called out the Arkansas National Guard. It created almost a mob-like mentality. When it came time to the first day of school, between the mob and the Arkansas National Guard, the Little Rock Nine, the boys and girls, the black boys and girls, were barred from entry. And the question is, what was going to happen next? Well, Judge Davies stepped in. He ordered a hearing. In fact, he ordered the governor, Faubus, to appear in his court on September the 20th. But before that could happen, Faubus actually met with the President of the United States. Eisenhower was on vacation in Newport, Rhode Island. Faubus made the trip there. They talked for about 20 minutes. And Ike said, look, we've got to implement the law. We've got to implement the order of the court. You don't have to pull the Arkansas National Guard out. Why don't you keep them there, but change their orders to actually help lead these 9 children into the school? Well, Faubus listened to Eisenhower, and Eisenhower actually made it pretty clear, you don't really want to mess with us on this one. He said in any area where the federal government had assumed jurisdiction, and this was upheld by the Supreme Court, there could only be one outcome. That is, the state would lose. So Faubus is on notice, but he returned to Arkansas, recognizing his political future was sort of based on this decision. He decided not to make a change. The Guard would stay there, and their orders were to keep these black children out. Well, the hearing in Judge Davies' courtroom occurred on September the 20th. Faubus didn't go. He sent his attorneys. They made an opening statement, and they basically left. And Faubus then issued an injunction against Faubus, or Davies issued the injunction against Faubus to actually disband this calling of the Arkansas National Guard. Well, they left, and the mob basically just took over. White men and women were there, and they were going to bar entry to these black children, to the point where William Mann, the mayor of Little Rock, basically said, I can't handle this situation. He appealed to the President of the United States, and Ike had a decision to make. What was he going to do? Dwight Eisenhower, again, never commented on the merits of the Brown v. Board decision, but he was committed to the rule of law, and that's what drove him to make the decision to send in the U.S. Army. The 101st Airborne was dispatched into Little Rock, Arkansas, and frankly, nobody was going to take them on. The Arkansas National Guard was actually nationalized by Eisenhower, mainly just to get them off to the side so that they wouldn't take orders from Faubus once they'd been nationalized. The 101st Airborne did that job. The Little Rock Nine took their place in school, and Eisenhower went on national television to talk about his decision. The very basis of our individual rights and freedoms depends upon the certainty that the president will enforce the decisions of the courts. Unless the president did so, anarchy would result. Mob rule cannot be allowed to override the decisions of our courts. A foundation of our American way of life is our national respect for the law. The troops are there solely for the purpose of preventing interference with the orders of the court. Again, this was not really about civil rights in Ike's framing. This was about the law and the orders of the courts, and that he was going to enforce regardless of the particular topic. And again, this enabled the Little Rock Nine to take their seats and start attending Central High School. In fact, Minniejean Brown, one of the Little Rock Nine, made the statement, "For the first time in my life, I felt like an American citizen." Ike became a hero to many in this case when it came to civil rights. It had a huge impact. Other communities started moving forward with their desegregation plans, but again, he was a reluctant path to getting to this point. And in other cases, he also signed into law 2 civil rights measures in 1957 and in 1960. There hadn't really been any civil rights legislation almost since Reconstruction, so these were sent as movements forward. But the truth is, they were dramatically watered down by Congress before they finally got to Ike's desk. The intent was to try to get the FBI more access to civil rights cases and also to protect voting rights of blacks. But again, it was pretty watered down. So again, glass half full, glass half empty. Better to have something moving things forward. But again, they were very modest decisions, kind of small steps on the path to civil rights advancement in the United States, which frankly is exactly the way Dwight Eisenhower wanted it as their president. That is Dwight Eisenhower, Ike and Civil Rights, from the life of Dwight Eisenhower. For more presidential chronicles, check out my books on Amazon.com. Don't forget to subscribe to my YouTube channel. Until next time, I'm David Fisher. This is Presidential Chronicles.